All right, then with that, Mr. McKeska, would you please begin the announcements?
Yes, Judge Drake McKeska, attorney for the department. Ms. Harrison-Bader.
I'll just go. Kathleen Savage, attorney for the respondent mother, Millie Welge. We're ready, Your Honor.
Ashley Koch, permanency supervisor with the law.
Richard Sotomayor, attorney for the child. Ready?
Charles Weatherby, attorney for Mr. Lippert. Mr. Lippert, if that's you on the Motorola Moto, would you unmute and announce, please? Well, that's his mother.
Amy Harding, Hill Country Casa supervisor, guardian ad litem for the child.
Dina Blackburn, Hill Country Casa, guardian ad litem for the child.
And I apologize, Judge, are you able to hear me?
I can hear you now.
Okay, April Harrison-Bader, permanency specialist with the law.
Judge is frozen. The person on the Motorola Moto, can you please identify who you are?
That's Ms. Lippert, Christina, the father's mother. And I've got him in contact with me on my phone, and I'm going to ask him to announce that he is his name and that he's here. If you'll say that, Mr. Lippert.
My name is Andrew Lippert.
And Miss
Is that everybody?
Miss Welge has joined us, Your Honor. If she could unmute and just announce her name for the record as well.
Well, I've got your volume kicked up now. The main thing is if you can hear what's being said.
Judge, I saw the mother move her mouth, but we can't hear her.
Millicent Welge, and I'm the mother.
Thank you. All right, Ms. Greenwald, did you get all the announcements?
Yes, sir.
Between the internet connection and everything else, want to make sure we got everything covered. And Ms. Lippert, Mr. Lippert's mother is still not connected to audio or video, so we're just going to have to move on. Okay, Mr. McKeska, what is the plan this morning?
Yes, Judge, we previously attended mediation, and we did reach an agreement in which the parents would submit affidavits of voluntary relinquishment for the child. They have both executed and filed those relinquishments, so we're here to prove those up today, Judge. I know the department was going to continue to pursue adoption by the maternal grandparents who were serving as placement of the child. And that was maybe not the entirety of it, Judge, but those were the highlights.
Okay, but the main thing you want to accomplish today is prove up relinquishments.
Correct, Judge.
Okay, then enable screen share. If you want, you may call your first witness.
Thank you, Judge. I would like to call Ms. Harrison-Bader. Ms. Harrison-Bader, can you please state your name for the record?
April Harrison-Bader.
And how are you currently employed?
I'm a permanency specialist with the law.
And you the permanency specialist that's assigned to Dylan's case?
Yes, I am.
Okay. And the parties previously attended mediation in this case, is that correct?
That is.
And as part of that mediated settlement agreement, both Ms. Welge and Mr. Lippert agreed to execute voluntary relinquishments of their parental rights?
Yes.
And have both parents executed those relinquishments?
They have.
And have both of those relinquishments been filed with the court?
Yes.
Okay, I've enabled the share screen function. Can you see the document that's currently on my screen?
Yes.
And that document's been pre-marked as petitioner's exhibit number 1, is that correct?
Correct.
Okay, can you please identify that document for me?
That is the affidavit of relinquishment for Millie Welge regarding
okay, and it has a file stamp of June 20th, 2023, is that correct?
Yes.
Okay, I'm gonna scroll down through the relinquishment to the signature page. Did Ms. Welge execute this voluntary relinquishment in front of 2 witnesses?
Yes.
And also in front of a notary?
Yes.
And prior to executing this relinquishment, did Ms. Welge have the opportunity to review it with her attorney?
She did.
And is it your understanding that Ms. Welge had the opportunity to ask any sort of clarifying questions of her attorney?
Yes.
Do you believe that Ms. Welge executed this relinquishment knowing the legal significance of that document?
Yes.
Did the department promise Ms. Welge anything in exchange for the relinquishment?
No.
Did the department threaten Ms. Walgie in any way, shape, or form?
No,
So is it your understanding that Ms. Walgie signed this relinquishment freely and voluntarily?
yes,
Okay. You also believe that Ms. Walgie executed this relinquishment, believing this in the best interest of her child?
yes, I do.
Okay. The judge would like to introduce petitioners one.
That's fine.
Ms. Harrison Bader, what is the current permanency goal for Andrew, or sorry, for Dylan?
It is a relative adoption.
And who's the prospective adoption placement or adoptive placement?
Dylan's maternal grandparents.
Okay. And is Dylan currently placed with his maternal grandparents?
Yes,
Have you had the opportunity to observe the relationship between Dylan and between Dylan and the grandparents?
yes.
Can you just describe that relationship for me?
Well, Dylan has resided with the maternal grandparents since he was born. He has a very strong bond with them. He does very well. Both the grandmother and the grandfather are aware of, his development, his medical needs, and things of that nature.
Okay. Have you had any concerns for the care that Dylan's received in the care of his grandparents?
No,
And are they currently becoming or going through the licensing process to become an adoptive home?
yes.
Can you just tell us where they are in that process at this time?
So from my understanding, they're actually moving pretty quickly through that. They do have to make some adjustments to their home to be in compliance with the high standards of licensing, but they are very much well on their way. They're completing classes and ensuring that their home is exactly what the CPA is wanting.
Okay. And do you foresee any sort of roadblocks with the completion of that permanency goal?
No, I don't.
Okay. And do you believe that permanency goal is in Dylan's best interest?
Yes, I do.
Okay. Pass the witness, Judge.
Any other witnesses?
No, Your Honor, the department rests.
Anybody else have a witness to call?
No, Your Honor.
No, Your Honor.
Mr. Saldivar, report.
Judge, the child's doing well with his grandparents. They're taking good care of him. He's healing from everything that happened in this case. And so I believe that the relinquishments of the parents is in the best interest of the child at this point. And I believe he's in a safe and stable home right now, and that that will be a home that will protect him going forward.
All right, thank you. Ms. Blackburn, Casa?
I have no questions.
Do you have anything you want to add on behalf of Casa?
I agree that the maternal grandparents are the best place for Dylan to be. They've kept up with his medical needs, and I think they will be going forward.
All right. Thank you. For the purposes of the final trial set for today, court will find that it has jurisdiction over the subject matter and the parties. Court finds that both parents in this case have executed affidavits of voluntary relinquishment of their parental rights, and those affidavits include waivers of service. The court will take notice of the waivers of service inside the affidavits, which have been admitted into evidence. The court finds that no evidence of any other court having continuing exclusive jurisdiction has been presented, and the court will find that this court is the court of continuing exclusive jurisdiction. Court finds that the parents have executed these relinquishments, and that the department, by and through 161.001 B1K of the Texas Family Code, have executed affidavits of relinquishment, and that it is in the best interest of the child to terminate both of their parental rights solely based on the ground. There was somebody talking. Did I miss something?
No, but you glitched, Judge, based on the K ground, you said?
Yes, pursuant to chapter 161.001 B1K, court finds that the termination of the parental rights is in the best interest of the children. Court finds that the permanency goal is relative adoption, and that the placement of the child with the maternal grandparents in Gillespie County is safe and appropriate in meeting Dylan's needs and in his best interest to continue. Court will name the Department of Family Protective Services as the permanent managing conservator of the child. Court, that's a permanency review for October 26th, 2023. That's October
Yes, Judge Drayton
6th,
Casca, attorney for the
2023.
department. Mr. Tucci.
Alejandra
11
Certuccia, Permanency Specialist for Belong.
Ashley Couch, Permanency Supervisor for Belong.
Farrell Cronwalgi-Sione for Mother Lindsay Grandstaff. Lindsay, if you would unmute and announce that you're present as well.
Lindsay Grandstaff, Mother.
Deborah Fuller, attorney ad litem for Joshua Grandstaff, Your Honor. He is not present. I contacted the facility and they needed a court order to have him present. And so he's not able to be present today, but I will talk to him tomorrow and let him know what about the hearing.
Okay.
Ron Colburn, guardian ad litem for the Grandstaff children.
Kendra Sims, attorney ad litem for the children.
Amy Harding, Hilton Shakasta supervisor.
Elise Telford, maternal grandmother.
Ms. Telford, could you do that again? It kind of glitched a little bit.
Elise Telford, maternal grandmother.
Thank you.
Jolie and Cody Sharp, fictive kin for Alexis.
All right, thank you. We're here today for a permanency review before final order. Ms. Certuccia, my understanding is at this time, permanency goal remains family reunification.
Yes.
Okay. And children are still in the same placements, and those placements are safe and appropriate, meeting their needs.
Yes.
And they're in the best interest of the children to continue in their placements.
I'm sorry, it's cutting out a lot. I wasn't able to get that.
I don't know what's going on with the internet here this morning, but it's terrible. Is it in the best interest of the children to remain in their current placements?
Yes.
And they're up to date on all of their checkups?
Yes. The only thing is Alexis, her dental, but that's scheduled for next month.
Any medical concerns at this time?
No medical concerns.
Okay. And are their educational needs being met? Are they ready for school?
Yes.
No, I'm sorry. Elizabeth that just had a cans.
No, it was Bryson.
Thought I read in the CASA report. Maybe it was.
Yeah,
I know Bryson had one previously.
Yes, that's correct. He had one, but it wasn't pulling up when we would try to get it. So we had to get him another one, and he got that one done.
Okay. And have you received the results?
Yes.
Any concerns?
No.
Okay. I had ordered at the last hearing for the children to have phone contact. And I know there was a visitation that took place in May. Is our sibling visits continuing?
Sorry, did you ask if the visits are continuing between the siblings?
Correct.
Yes, they had one in June for Elizabeth's 12th birthday that took place in Woodway, I believe, or if not, it was in Fairfield.
And are those visits appropriate?
Yes. There were some concerns shared between some, I guess, disagreements between Elizabeth and Alexis, which has been an ongoing concern for the family. So we are looking into a sibling therapy for Elizabeth and Alexis.
Okay. And what sort of contact are the children having with the mother?
So right now we have 4 hours unsupervised visits every other week for Alexis and Lindsay. And then we have 4 hours supervised every other week with Elizabeth and Bryson. And then every other weekend supervised overnight visits.
Okay, I heard you have 4 hours unsupervised every other week for Alexis and Lindsay, and then you broke up. What did you say after that?
And then 4 hours supervised every other week with Elizabeth and Bryson, and then every other weekend supervised overnight visits.
Which on the supervised overnight visits, who's doing that?
It can take place at Miss Telford's home or at Lindsay's grandmother's house, Miss Stone. That's in Woodway.
But which children? That's what I haven't gotten yet. Is every other weekend supervised overnights? Which children is that?
I'm sorry, I'm having a very hard time hearing you.
On the every other weekend supervised overnight visits, is that the 2 youngest children or is that all the children?
That's the 2 youngest children.
Okay, thank you. Is all of that appropriate at this time, or are you asking for any changes?
We would like to get some changes between Alexis and Lindsay to reduce their visitation after some issues that they've been having during their unsupervised visits. We got them into family therapy, so we were going to limit it to them seeing each other for those family therapy sessions only, which will take place once a week. And then we were going to go from there. And then as far as Elizabeth and
Well,
Bryson,
hang on. Let's stop there. What are the concerns? That's okay. What are the concerns?
so there's just been during those visits, after the visits, there's something going on either from Alexis telling me about how she's worried about how her mom is, or from Lindsay to me expressing how she's concerned about Alexis, and Alexis can get upset during their visits. And their most recent visit, it got ended early where Alexis's placement had to go pick her up. I think they only went 2 hours into the visit.
And it was supposed to be overnight?
No, it was just supposed to be their 4 hours unsupervised visit.
Okay. Is that the only visitation change you're requesting?
No, we were also I'm waiting on approval from Miss Sims about the limitations on the unsupervised visits for Lindsay with Elizabeth and Bryson. And they've also approved for overnight visitation, 1 to 2 nights per week, supervised at Miss Telford's home.
You believe those changes would be in the best interest of the children?
I do.
Is Miss Grandstaff mother, is she in compliance with her family plan of service?
Yes, she is.
Do you have a copy of it?
I do, and she has one as well.
Okay. And Mr. Grandstaff is still incarcerated
Yes,
and he's not in compliance?
not at this time.
Does he have a copy of his family plan of service?
He does.
As of today, would it be safe to return the children to either parent?
Not at this time.
As of today, have either parent fully addressed the concerns that brought the children into the care of the department?
I wouldn't say fully, no.
Mr. McCaskill, do you have any questions for Ms. Tucci?
Mr. Tucci, do you believe that mediation would be appropriate in this case?
I do.
And are you asking the court to order the parties to attend mediation prior to the trial setting?
Yes.
Okay. Pass the witness, Judge.
Ms. Sioni?
Good morning, Mr. Tucci. What is it that Lindsay needs to do to fully address the concerns?
So we just want her therapy notes to reflect some more of the domestic violence concerns that we've had.
I mean, there were some issues getting that started timely. So that also falls back on our providers. But we just wanted to complete that BIP program, and then with her individual counseling, go over some more of the issues with the domestic violence, which I believe, according to her June notes, it's what's going to be addressed in her next session.
And I know that family counseling has been established for Ms. Grandstaff and Alexis. Has Alexis received a new counselor yet?
No, not yet, but we are going to see if the same therapist that's going to be meeting with them together will be able to see her individually as well.
I'll pass the witness.
Ms. Fuller?
Mr. Tucci, in regards to Mr. Grandstaff, when he was in the Gillespie County Jail, was Belong able to provide him any services?
Belong was not, and the facility that he was in did not have any services available to him.
Did Belong attempt to do any kind of assessments or, do anything by Zoom at the Gillespie County Jail?
No, we did not. I asked if they had any classes for him to take, but they said that they didn't have anything for him.
Okay, well, the jail didn't have any, but did Belong attempt to set anything up with their providers?
I'm not aware of any providers that would be able to do that for our clients that are incarcerated.
Okay, but did you look into it?
No, I did not.
Okay. In regards to him moving, he's moved a couple times since he left Gillespie, correct?
That's correct.
But prior to leaving Gillespie, did he have some virtual visitation with the younger children?
He did. He had 2 virtual calls.
And how did that go?
They were appropriate, as Ms. Telford reported to me. They went very well. Bryson was emotional when he first saw him because it had been months since they had seen each other. But overall, the visits went well, and he was appropriate with them.
And have you contacted the facility that he's in now to determine whether he can have visitation?
Yes, I have, and I asked, and they're unable to accommodate him for that.
Okay. And the unit, the bird unit that he's in right now, that's not the Safe P unit. That's not where he's going to receive the Safe P program, correct?
No, the way it was explained to me was that he is being transported to several facilities until he is at his main one. But I think he's being assessed at these facilities where he's stopping.
And so do you receive any kind of notice, or you just look it up to determine where he's at?
I don't get any notice. I look him up every week to see if he's moved.
Okay. And so if it's a possibility in the future for him to have the virtual visitation at one of these facilities, is Belong going to be willing to do that?
Yes.
Okay. And can Belong provide him any services in the prison system versus the jail system?
I can look into it, and then I will get back and share with you.
Okay. And then can you provide my office with a copy of his family plan of service?
Yes, I can.
Okay. I'll pass the witness, Your Honor.
Anybody else have any other witnesses they want to call?
Judge, I'd like to call Ms. Grandstaff briefly.
Okay.
Ms. Grandstaff, you had some concerns about the counseling for Alexis and had some specific requests, correct?
She's gone. Let's give it a minute and see if she comes back. While we're waiting for her, does anybody else have a witness they wanted to call?
No, Your Honor.
I don't know if you maybe want to proffer, Ms. Sioni, what you had intended to elicit from Ms. Grandstaff.
Judge, I think that I can certainly do that. I think there was a couple of recommendations in Alexis's psychological evaluation for specific types of counseling that would be beneficial for her related to ADHD. And then the other type of counseling was more specific trauma counseling. I understand she's graduated from counseling, but I think that's because the counselors may be going on maternity leave. Ms. Grandstaff was concerned about those issues and wanted to ensure that she gets the specific kind of counseling that would benefit her.
Okay. Does anybody else have anything to say about that? Ms. Ftucci, are you aware of those concerns, and are you able to work with the counselors to make sure that those concerns are addressed?
Yes, so I was going to chime in. The counselor that she has right now is going on maternity leave, but I believe they had like a specific treatment plan for Alexis, and that's what she was graduating from. But they were going to work on transferring her to another therapist, and I shared that information with Jolie, Miss Snell, and they were going to look into that for her. But like I had said, we were going to try to see if the same counselor that's seeing them for the family therapy will be able to see her for individual therapy.
Okay. All right. Ms. Sims, any report you want to give?
Yes, Your Honor. Elizabeth and Bryson are doing very well. Miss Telford's on top of everything with them. They're seeing their counselors. They're getting ready to go back to school. I have no concerns with them whatsoever. Both kids report they love seeing mom and that the visits go well and everything's appropriate. Alexis, she's doing well. She still has some issues that she needs to work through. I agree with Miss Grandstaff, like she still needs to be in counseling. I also think it's a wonderful idea. Her and mom start family counseling. I think that would address a bunch of issues. And I think when it's appropriate, when the counselor thinks it's appropriate, I think bringing Elizabeth into family counseling would be good for both Alexis' mom and Elizabeth. Alexis did start some ADHD medicine. She reported to me that she can't really tell yet, but she really hasn't done anything that she has to focus on. So, she said she wants to wait, give school a couple of months and then see how it's going then. But other than that, I mean, her placement's good. She seems to have good friends. Whenever I talk to her, she's in a good frame of mind. She seems happy.
Thank you. Mr. Colburn?
Morning, Your Honor. Constance in agreement that some priority needs to be put forth on the counseling sessions between Alexis and her mother. We know there's some deep-rooted situations there that need to be addressed, and I think that's imperative for the well-being of both of those women, particularly with her mother's progression through her treatment plan. So that we would like for that to be the focus here very quickly.
All right. I did read that in the report. Okay. Any argument from the attorney? Anything else?
Your Honor, I just wanted to bring the court up to date. My client, the possibility of him being moved is very likely, and they're very strict about having him appear for court hearings, mediation. And so I just want to make the court aware it could be difficult because they have to have 14 days notice, but he could be gone by the time I get the notice to them in the court order. They must have a court order for any type of participation, whether it's mediation or court. But there's no guarantee that he'll even be there 2 weeks, 3 weeks at where he's at right now. So I just wanted to make the court aware of that. He was hoping to do his services once he got to Safe P, because that program would be pretty extensive, but he's not at Safe P yet.
Understood. Our trial date is October the 26th. So there is time to get this thing mediated and to give Ms. Fuller plenty of lead time to at least get the notice to whatever facility Mr. Grandstaff may be in. But I do understand that he could be moved. So what I would suggest in that situation, Ms. Fuller, is just to make sure you have authority. And if it turns out that they do not produce him for mediation, as long as you have authority, then I'll excuse him from the requirement to be there. Okay. For the purposes of the permanency review before final order, the court finds the permanency goal of family reunification is in the best interest of the children. Court finds that the placements the children in are safe or appropriate, meeting their needs and in their best interest to continue. I do want everybody to keep an eye on this thing with Alexis and her mother. I'm going to order the family counseling between Alexis and Ms. Grandstaff. I'm going to order that Alexis remain in her own counseling. And then I think Ms. Sims has a good point. When it's appropriate, we need to bring Elizabeth safe. If we're looking at family reunification with the trial date in October, probably needs to begin pretty quick. We're kind of running out of time to wait until everything's just right. So I'm going to order that family counseling begin immediately. I'm going to find that the children are up to date on their medical, dental, and vision, with the exception that Alexis needs her dental, but I understand it's scheduled. Court finds their educational needs are being met. Court finds that Ms. Grandstaff is in compliance with her family plan of service. Mr. Grandstaff is not. They both have a copy of their family plan of service. I'm going to approve the requested visitation changes. I think reducing the visitation between Ms. Grandstaff and Alexis, I don't want that to be punitive in nature, and I don't want that to be permanent. I just want to get them in therapy, figure out what's going on and address it. I want them to have that visitation, but I don't want there to be any other blow up. So I think just for now, let's have them meet in therapy soon. And then if they get these issues worked out, you don't have to come back to court. Just start that visitation up again. But let's see if we can figure out what's going on there first. If they're both contacting Ms. Tuche or somebody else, and they're both expressing concerns about each other, then obviously there's some kind of communication problem. Obviously there's something that they're not talking out, and they should be at this age. Alexis is 15. She should be able to have these kind of conversations with her mom, and her mom should be able to have these kind of conversations with her. That's part of the mother-daughter bond, and it's very concerning to me that they're not able to do that right now, and hopefully that can be addressed through the family therapy. I'll find that part of Mr. Grandstaff's reasons for not being in compliance are because of his incarceration, but he does have a copy of his family plan of service, and he understands what's expected of him. So it's just one of those situations where we're going to have to do the best we can. We'll also make a finding that as of today, neither parent has fully addressed the concerns that brought the children into the care of the department, and that as of today, it would not be safe to return the children to either parent. I'm going to order the parties to mediation, and I'll excuse Mr. Grandstaff in the event there's some logistical issue, he gets moved or whatever the case is, and just make sure, Ms. Fuller, again, that you have authority. We'll be back for final trial October 26th, 2023 at 9:30. October 26th, 2023 at 9:30. And I have to admonish the parents, the state of Texas gives parents in CPS cases 12 months to demonstrate that you can provide a safe, stable, violence, and drug-free home for your children. If you cannot do so, your rights to your child are subject to restriction, as they are now, or termination. Mr. McCaskill, is there anything I failed to address?
No, Judge.
Okay.
Your Honor, I just had one other issue. I just wanted to make sure that they, CPS Belong would continue to talk to the facilities about visitation. I confirmed that he has no visitation at this time where he's at, but when he finally makes it to Safe P, he would be allowed to have some kind of virtual contact. Right now he cannot, but if we can just stay on top of that for when he gets moved, because it was appropriate is my understanding, and the children enjoyed the contact.
I think that would be good. I agree that when and if it's appropriate, that needs to be a priority, especially if the children benefited from it. So we can put that in the order too, Mr. McCaskill.
Yes, Judge.
Okay. Well, thank you all for your time and your service. It's the Sharps, right? It says Jolie Snell, but it's the Sharps, correct? Okay. To you too, and to you, Ms. Telford, really appreciate what you're doing for the kids. Thank you so much. I'm really glad to hear that they're all doing well with each of you, and that's huge in this case. So thank you. Okay. All parties are excused. Thank you.
Katarina Lewis, Permanency Specialist.
Ashley Couch, Permanency Supervisor with Belong.
Kathleen Savage, attorney for the respondent mother. Ms. Caldwell, can you please announce your name for the record?
Mariah Caldwell.
Richard Saldivar, attorney for the father, who's not present. He's incarcerated. Judge, I announce not ready just because he's not here.
Cheryl Sione, attorney ad litem for Millie.
Amy Harding, Hill Country Casa, guardian ad litem for the child.
All right. What is the permanency goal at this time?
Family reunification.
And there's no Indian child heritage in this suit?
No.
Okay. And is the placement with Ms. Hoffert safe and appropriate, meeting the child's needs?
Yes.
And is it in Millie's best interest to continue in that placement?
Yes, at this time.
Okay. And Millie is up to date on everything?
Yes.
No concerns?
No, she's doing really well.
No developmental delays?
Not that any have been brought up. We did put in an ECI referral just so that is in, and they should be contacting Ms. Hoffert.
Okay. And what sort of contact, if any, is she having with the mother?
Right now it's just virtual calls. Right now, Miss Mariah Caldwell is currently an inpatient. So we are actually working on getting her up to Kerrville area so we can do a in-person visit.
And at this point in time, is Ms. Caldwell in compliance with her family plan of service?
Yes.
She's currently in inpatient. And
Yes.
okay. Does she have a copy of her family plan of service?
Not at this time. We were able to finish our family group conference that we started. We had to reschedule due to Ms. Caldwell being a little late due to a doctor's appointment. It wasn't her fault. It was just the bus system and everything. So we did have to reschedule, but we did create it and file the family plan.
Okay. So then when you had the FGC, father obviously didn't participate, but family plans of service were created for both parents.
Yes.
I know they didn't have the opportunity to participate, but has Ms. Caldwell been able to review it?
She has not, but I do plan on doing that soon.
Have you sent a copy to the father, Mr. Rodriguez?
I have not been able to, but I plan to get with his courtesy worker so she can take a hard copy out there to the jail for him.
Do you believe that the family plan of service that was created is narrowly tailored to address the concerns that brought the child into the care of the department?
I do.
Do you believe that the family plan of service for each parent is in the best interest of the child?
Yes.
Are you asking the court to adopt and approve the family plans of service that are on file as orders of the court?
Yes.
Would you say that Ms. Caldwell is cooperating at this time?
Yes.
All right. And I know he's incarcerated, but is Mr. Rodriguez cooperating with you?
Yes.
As of today, would it be safe to return the child to either parent?
No.
And as of today, have either parent fully addressed the concerns that brought the child into the care of the department?
No.
Ms. Savage?
Will Ms. Caldwell be able to begin her services at her inpatient facility?
Yes.
Okay. And the department will be able to get those notes from the providers there?
Yes.
And in regards to Millie, will she be able to eventually be placed with Ms. Caldwell at that facility?
That is a possibility. I would have to, of course, staff that as a reunification, but yes, that could be a possibility down the road.
Okay. And are we looking for potential visitations at the facility down the road?
I would have to staff that with my supervisor, but that could be a possibility at this time. I think we were going to ask Ms. Caldwell to come up to the Kerrville area.
Okay. Is she able to get transportation assistance from the facility?
Yes, we've spoken with her counselor and there are 2 people there that are willing to drive her up there. So I was going to get their numbers and get that going.
Okay. And because the distance with those visitations be longer in duration?
Yes.
And how quickly are we anticipating trying to get her an in-person visit with Millie?
If we can get it next week, I would like to do it next week.
I'll pass witness, Your Honor.
Mr. Saldivar?
Yes, to your knowledge, how long has dad been incarcerated?
I believe about 3 weeks now.
Okay, are these new charges or something that was just old that came up again?
To my knowledge, I know there were a few warrants that he had out, so I believe they're old charges.
Okay, and do you know when he might be released from jail?
I don't. The courtesy worker was able to go out and meet with him, and he had no idea when he was going to get out. He just said that he would probably be transferred to Harris County because right now he's in Montgomery County.
Okay, do you know when that transfer was going to happen?
I need to check. I want to say probably within this week or next week. He said about 10 to 15 days from when last week. Yeah.
Once he lands, will you find out if the jail can offer him any services that he can get done while he's there?
Yes.
Okay, and you will ensure that he gets a hard copy of his family plan?
Of course, yes.
And to your knowledge, did the courtesy worker, was she able to go over any of the services with him? Well, she did talk to him?
She had not been able to, but I was able to kind of talk to him when I met with him the first time, and we kind of talked about what the services would look like. We hadn't completely created the family plan of service yet when she went out to see him. So, but I did give her a copy, so she should be able to go out there and go over that.
Okay, and to your knowledge, was he agreeable to work the services that you were proposing?
Yes, he did say he would work them.
Okay, did he provide you with any family members for possible placement of the child?
Yes, we actually have a current pending home study for Sally. Well, I can't remember her last name, but a cousin of his. However, he did report to the courtesy worker that he doesn't want us to move Millie right now. He would like her to stay with Miss Hoffert as long as she's able to care for Millie right now.
Okay.
Anything further from the department?
No, Judge.
Anybody else have a witness to call?
Judge, Millie is doing wonderfully in her placement, and I agree with Dad that she should stay there as long as Ms. Halford is able to maintain that placement. If I remember correctly, as far as the visitation, I think that the court ordered at the prior hearing 4 hours once a month or 2 hours twice a month. So it would seem that since mom's only getting one visit, the 4 hours would be appropriate. And I believe the court also ordered that the parties travel to Millie. So arranging the transportation is, I believe, appropriate. She's very small. It's a long drive for her. So if we can make that work as it's set up, that would be great. But other than that, she's doing wonderful.
Thank you, Ms. Sioni. Casa?
Thank you, Your Honor. Since our report was filed and written, we were able to have a family group conference in this case. And despite Ms. Caldwell being at an appointment and not being able to join for the whole meeting, there was a case manager from her treatment facility at the meeting and was able to share with us a great deal about the program that she's entered and the services available to her. I was quite impressed with that program and am very pleased that Ms. Caldwell is committed to working that program, not only for the care of Millie, but for her unborn child as well. And so I think that she's exactly where she needs to be, and I want to see her to continue to engage in those services. Millie is doing exceptionally well with Ms. Hoffert. Ms. Hoffert does have custody of Millie's older half-brother. And so she is placed with a half sibling, which I think is lovely. The two of them adore each other, and she is having all of her needs met. I have no concerns for her safety or well-being at this time, and I'm really pleased with the choices that the parents are making at this point to rehabilitate and address their issues that brought us here.
Thank you, Ms. Harding. Okay, then for the purposes of the status hearing, the court will find there's no Indian child heritage in this suit. The permanency goal at this time is family reunification. Placement for Millie is safe and appropriate and meeting her needs and in her best interest to continue. Court finds that she's up to date on all her checkups and she has no concerns at this time, no developmental delays. Court finds that an ECI referral has been initiated. Court finds that Ms. Caldwell is in compliance with her family plan of service. Ms. Caldwell, I'm very proud of you and happy to see that you're an inpatient getting help. That's a huge step, and I hope you're proud of yourself. Court finds that family plans of service were created for the parents They did not participate and have not yet reviewed. However, family plans of service are on file and they're narrowly tailored to address the concerns that brought the child into the care of the department. Court will find the family plans of service are in the best interest of the child and make them orders of the court, and order belong to make sure that both parents get a hard copy. Court finds that both parents are cooperating at this time, and that as of today, it's not safe to return the child to either parent, and neither parent has fully addressed the concerns that brought Millie into care. But it sounds like, as of the status hearing, that we're on the right track. Mr. McKeska, good things are being done. So I'm
Director McKeska, attorney for the department. Ms. Harrison Bader.
Permanency specialist with Belong.
Ashley Koch, Permanency Supervisor with Belong.
Anna Swallow, attorney ad litem for the respondent mother. Letha Hines, I see she's connecting right now.
Deborah Fuller, attorney for Robert Smith, who will not be attending today, Your Honor.
Kendra Sims, attorney ad litem for the children.
Amy Harding, Hill Country Casa Supervisor, guardian ad litem for the children.
And then we've got Miss Hatley as well. Miss Hatley, can you unmute and announce, please?
Yes, Denise Hatley.
And then Lisa's iPhone.
It's both Lisa Medlock and William Shipman.
Thank you.
We decided just to use one phone because we're in the same house.
That's fine.
Judge, they're on the next hearing.
Okay. I was going to say, I don't think they're even on this hearing. All right. I'm going to put you back in the waiting room. Okay.
Charles Weatherby, and I don't think Mr. Hatley's going to be here. I have not been able to contact him. He's still trying to get into a rehab. The bed was full on the first one that he missed.
There's no Indian Child Heritage in this suit at this time, correct?
Correct.
A permanency goal at this time?
Family reunification.
All right. Placement of the children is safe and appropriate, meeting their needs?
Yes.
And that's still with the relative in Comal County?
Correct.
All right. And they're up to date on all their checkups, but they need dentals?
They do need dentals, and I believe either their cans have been scheduled or Ms. Hatley was waiting on those appointments to be scheduled.
Okay. At this time, there are no other concerns or delays?
No, sir.
Okay. They're not receiving any psychotropic medications?
No, sir.
All right. And my understanding is the parties were able to hold a family group conference. Mr. Smith participated in the creation of his plan. Ms. Hines was not able to participate due to an appointment, and Mr. Hatley did not participate. Is that correct?
That is correct. Ms. Hines was unable to participate because she was in rehab, which is where she is now.
Right. Okay. And then the family plans of service that were created, have they been filed?
Yes, sir.
Okay. Are those plans narrowly tailored to address the concerns that brought the children into the care of the department?
Yes, sir.
Your Honor, I'm going to object to my client's family plan. It was not gone over with my client, and it does not reflect the family group conference that we had and all the services that we discussed there. So I'm concerned that it was filed. He was not contacted. He did not sign it. He did not have an opportunity to review it, and it does not have everything that it has more than we discussed in the family group conference. And so I'm objecting to the family plan that was filed. Also, for some reason, they have the wrong address for me on their court report, and I'm not sure why that happened, but I am concerned that the court report and the family plan were just filed on the 25th, and my client did not have an opportunity to review it, sign it, or even go over it with myself.
Okay. Any response to the objection?
Judge, the family code requires the department to file the family plan prior to the status hearing. Actually, the family code actually requires that it be filed within 45 days of the removal. 263-103 C also requires that or allows the department to file the original family plan without a parent's signature. And so I will be happy to hold a review conference to ensure that, the services and everything that are on the family plan are what was discussed during the family group conference. As soon as Mr. Smith is able to review and sign it, then we'll file an amended family plan as required by the code. But the family code does require the department to file the family plan of service with or without a parent's signature prior to the status hearing.
All right.
And it has been more than 45 days since the removal.
All right. Well, the objections noted. I'll take that up when I make my order. I've heard Mr. McKeska's response. So let me go ahead and continue my questioning of Ms. Bader. So with that objection, Ms. Harrison Bader, are you asking the court to adopt and approve the family plans of service as orders of the court?
Yes, sir.
Okay. And I don't remember if I asked you, are they narrowly tailored?
Yes, sir.
Okay. And you believe it's in the best interest of the children to make those plans orders of the court?
Yes, sir.
All right. Are the parents cooperating with you?
I have been unable to get in touch with Mr. Hatley. I actually was told by the prior caseworker that there was a courtesy worker assigned for the family-based case that did go out to see him on the 24th. And he was not in rehab and didn't appear to be going. But I myself have still been unable to make contact with him. Mr. Smith is responsive to text messages, and Ms. Hines has communicated with me since entering rehab as well.
Okay. As of today, would it be safe to return the children to either parent or any parent?
No, sir.
As of today, has any parent fully addressed the concerns that brought the children into the care of the department?
No, sir.
All right. Now, I know Mr. Smith has no visitation until his DNA test is done. Where are we with the DNA test?
I believe a referral has been created. It is definitely in the process of getting done for him.
Okay. I'd ordered that mom have visitation once a week by video during inpatient. Has she had one yet? I know she's only been there a little while.
Yes, so Ms. Hatley has graciously agreed to supervise those virtual visits, as Ms. Hines is only available to do them on the weekends, and I do believe they did one this past weekend. We also discussed with Ms. Hines doing that in-person visit while she remains in rehab. Unfortunately, she is not allowed visitors during the time that she is in rehab.
Okay. Do you believe that the current visitation schedules that I ordered last week remain in the best interest of the children?
Yes.
Okay. Mr. McKeska, any questions for Ms. Harrison Bader?
No, Your Honor.
Ms. Swallow?
Thank you, Judge. Ms. Harrison, although my client was not present at the family group conference, I participated, correct?
Yes, ma'am.
And is it your understanding that I had authority to participate and assist with formulating the family plan on behalf of my client?
Yes, ma'am.
Okay. What services are you requesting my client complete?
So, and I don't have the family plan right in front of me, but we would like to have a monthly household budget for her, as well as for Ms. Hines to keep us updated to any addresses that she moves to. So that way we are able to effectively and efficiently provide services to her. We are requesting that she complete another psychological and also be connected with a new therapist as she was discharged from the last one. We are asking that as she is in rehab right now, an OSAR is not necessary. It was put into the plan prior to her going. But we are asking that she complete rehab and that she participate in random drug testing. And once she is out of rehab, if she does come back with a positive drug test, we will then ask her to complete the OSAR. We are not asking her to do parenting classes, but I did speak with her and the rehab does offer them. So that will be up to her if she wants to do that. And we're also asking for domestic violence classes.
Thank you. And have you identified a provider for the domestic violence classes?
So there is one that is out of San Antonio that offers virtual So that might be something she'd be able to do while in rehab if able to, or once she is out, as she has indicated she wants to remain in the area that she's currently in. She has also informed me that the rehab does have a domestic violence program that they offer during the course of her treatment.
Would the department be willing to accept the domestic violence program that's being offered at her facility?
So I believe I would just want some information about what is actually offered in the class. And I believe there was also a conversation had about whether or not it would be a good idea for her to participate in domestic violence at the same time that she's addressing her alcohol addiction. But I do believe that we can have a discussion regarding whether or not that would be accepted.
Okay, and your testimony and through my conversations with you via email, it seems to be that my client is interested in establishing herself in the Abilene area upon discharge, correct? I'm sorry, you cut out.
Oh, yes, ma'am.
Okay, and so with that being said, a lot of the services on the family plan, the providers are in, either the within the Gillespie County area or the San Antonio area. Will you be amending your family plan to reflect those services in the area where she ends up establishing herself?
Yes, I absolutely can. And even from the beginning, I am more than happy to send to other service providers in her area. With that being said, the majority of the services that she will be referred for do offer virtual services. So if she's okay with doing that, then we can stick with those service providers. Otherwise, I'm more than happy to work with her.
Okay. And as far as a therapist for the children, has one been identified?
I met with Miss Hatley this past Saturday and spoke with her about that. And I told her I would give her a little bit of time to be able to connect with one. However, I believe we discussed them needing in-person therapy, but we wanted to look in to see if the therapist that they were seeing previously, if we may be able to work out something for them to continue seeing that therapist due to having an established relationship. But if by beginning of next week, if we don't have something, I will be reaching out and finding a therapist for them myself.
Okay. Now that therapist that they were seeing, she's not local, is she?
She is not local.
Okay. And that's pretty important because we need consistent therapy for these children.
That is correct. Yes.
Okay. And I'm not sure if the order stated previously that the therapy for the kids would be from a local provider. Don't you think that would be in the children's best interest?
I do. I do, however, believe that if the therapist that they were seeing is willing to meet them where they are, that it might be a good idea to stay with a therapist that they have an established relationship with. But definitely, if they're not able to do that, yes, they need to have somebody who is local that they can see consistently without any hardships.
So are you aware that this therapist, although she was good for the children for the time that she was able to see them, but she has not seen the children in quite some time? And my understanding is that's due to distance. Are you aware of that?
I was not aware of that.
Okay. So will you keep that in mind while you're searching for a therapist?
Yes, absolutely.
Okay. Thank you. I pass the witness.
Mr. Melody.
No questions, Your Honor.
Ms. Fuller.
In regards to the placement of Benjamin, is there any concerns about that placement?
No, I don't have any concerns for his placement.
Was there an issue with an individual with criminal history in the home?
No, there's not a person in the home with a criminal history. There was a concern with a family member that had criminal history that was previously approved as somebody who could be around the children. As soon as our service stage saw that, we immediately amended that, and he is not allowed to be alone with the children.
Okay, and he was previously a caregiver?
Prior to the case actually coming over to permanency, I don't know that he was alone with the children, just that he was approved.
Okay. And so that situation has been resolved?
Yes, ma'am.
Okay. And in regards to the DNA testing, you said you don't have any information for it being set up yet or any of that?
I believe it's in like progress. I think they were trying to connect with Mr. Smith to determine where to go potentially, but it's pretty much ready to go.
Okay. And did he send you information in regards to the LabCorp that was close to his residence in the town that he lived in?
Yes, he did.
Okay. And did you forward that to the legal department?
I don't know if I forwarded it to the legal department. I shared it with my supervisor.
Okay. So can you share that with your attorney so they can try to set up the DNA with a closest facility? Since
Absolutely.
they typically use LabCorp?
Yes, ma'am.
Okay. And then is Benjamin in therapy now? Because I know we're working toward eventually discussing with him parentage, but is he in therapy at this point?
No, ma'am. He has not started with therapy yet.
And when do you think that's going to happen?
We were given 3 weeks at the adversary, and it will be prior to that deadline.
And what services are you asking Mr. Smith to do?
We are asking for him to submit for the DNA test. We are wanting him to take just one UA and hair follicle drug test just to confirm that there is no recent drug use by him due to his history. I am asking for a household budget for him as well as proof of employment. And then we are also asking for him to participate in family therapy with Ben once it is considered appropriate by Ben's therapist.
Okay. And when we were at the family group conference, there was no discussion of a budget at that time, was there? I mean, there was a discussion of where he worked, but no one mentioned anything about a budget.
I believe that is correct. We did not go in depth into that portion of the family plan.
And then in regards to the drug testing, Mr. Smith agreed to do a UA, but I mean, he hasn't been involved with the legal system since 2014. And so we discussed him doing a UA, and the notes for the family group conference coordinators indicate he was going to do a general drug test, a UA, not a hair follicle. So
my understanding was that we did discuss doing a hair follicle, but that is something that we can go back and verify. I definitely don't have a problem with doing that.
And for his employment, do you want pay stubs or you want a letter from the employer?
I think pay stubs would be perfectly fine.
Okay. And was there also a request? I remember a request for a psychosocial.
Yes, ma'am, you are correct. And
Okay.
I did forget to mention that we are requesting a psychosocial.
Okay. And have you been able to locate any providers up there in his area?
No, ma'am, I have not, but I do believe we may be able to find somebody in this area that would be able to do that with him virtually. And I will try that avenue first before we seek outside providers.
Thank you. I'll pass the.
Excuse me, Ms. Sims.
No questions, Your Honor.
Any other witnesses, Mr. McKeska?
No, Your Honor.
All right, we're at 10:55. Does anybody else have a witness they need to call briefly?
No, Your Honor.
No, Your Honor.
All right, Ms. Sims, do you want to go and give me your report, please?
Yes, sir. I did get to visit with the children for quite a while this past weekend. They both seem to be doing very well in placement with Miss Hadley. They're both very sweet. I was so impressed with him. He is like so sweet to his little sister. I do think after visiting with them, I think we need to do an in-person therapy. I don't think either one of them would do well with virtual. But other than that, I mean, placement seems to be going very well and the kids seem to be doing very well in it.
Okay, very good. Thank you. Ms. Harding?
Your Honor, we're really pleased with the current placement and agree that the children would benefit from in-person therapy over virtual therapy. I'm really excited to see Ms. Hines in an inpatient program and committed to addressing the issues that brought her children to foster care. So I hope she continues to do that. And we're pleased with where we are at this point. So.
All right. Okay. Then for the purposes of the status hearing, court finds there's no Indian child heritage in this suit. At the permanency goal, I know we're at status hearing, but there is a permanency goal, family reunification. Court finds that the placement of the, excuse me, I've got things beeping in at me. Court finds that the placement of the children is safe and appropriate, meeting their needs and in their best interest to continue. Court finds that they're up to date. However, they do need dentals. Court finds that assessments have been scheduled and there are no other concerns at this time, and no psychotropics at this time either. All right, regarding the family plans of service. So I'm going to order that the Belong work with Ms. Fuller and Mr. Smith to go over that plan before I make it an order of the court. I'm going to take judicial notice that it was filed, but let's go over it. And then I'm going to basically abate making his family plan of service an order of the court. I am going to make Ms. Hines and Mr. Hatley's orders of the court. I'm going to find that Mr. Smith participated in the creation of his plan. Mr. Hatley and Ms. Hines did not. Understandably, Ms. Hines is in rehab and dealing with appointments, so she couldn't be there. However, her attorney was. Court finds that those plans were narrowly tailored and in the best interest of the children. However, again, I'm abating the order on Mr. Smith's plan. I'll find that Mr. Smith and Ms. Hines are cooperating with the departments. Mr. Hatley is not. Court makes a finding that it's not safe to return the children to either parent today, and that as of today, neither parent has fully addressed the concerns that brought the children into the care of the department. Court finds the current visitation orders are appropriate and makes no changes to those. Will distribute pretrial scheduling orders and discovery control plans. Please review those for dates and times of future hearings and discovery deadlines. I have to admonish the parents that the state of Texas gives parents in CPS cases 12 months to demonstrate you can provide a safe, stable, violence and drug-free home for your child. In the event you cannot do so, your rights to your child can remain or be further restricted as they are now or be terminated. Ms. Hines, I'm really glad to see that you're an inpatient. I think that that's going to do amazing things for you. And I think it's going to open a lot of doors and open your eyes to a lot of things that have been happening in your life. I hope that you will continue to engage in services and get the help that you can get there. And Ms. Harrison Bader, your attorney, Ms. Swallow, the ad litem, Ms. Sims, they're all very experienced and know what they're doing. And I encourage you to rely on them. CASA as well. Disappointed to hear Mr. Hatley has not engaged in anything yet, but unfortunately, I'm not surprised. Hopefully he will. And then as far as Mr. Smith is concerned, let's get that order, that plan looked at and determine whether or not anything needs to be changed. And then I do understand that once Ms. Hines is released from inpatient, that that family plan of service will need some amendments just to take up geographical and logistical issues. Okay, good luck to you all. Ms. Hines, I'm proud of you. And if nothing further, all parties are excused.
Thank you.
Thank you.
Thank you.
Department of Family Protective Services versus Lisa Medlock and William Shipman in the 216th Judicial District Court of Gillespie County, Texas. This is a Texas Families First family preservation case. However, after further reviewing the case, I realized this morning that I may have had a conflict, and we just had a conference in the breakout room where we did some research, and Ms. McKetta was able to discover that back in 2019, I did represent William Kelly. And so that conflicts me out of hearing this case as a judge. So the case is going to be referred to the court's conflict docket with Judge Kathy Morris. And this case will be reset to August 2nd, 2023 at 2 p.m. with docket. All right. Thank you all for your time and your service. If nothing further, all parties are excused.
I have a question.
Ma'am, I can't do anything on this case.
It was just about the next court date. I have work that day, but I get off at 2.
You'll have to take that up with your attorney in the court. Chances are, if you get off at 2, you'll probably be okay. But I'm not able to do anything else. That's when we have to hear it. Okay. I understand it's an inconvenience to you, but I can't hear your case. I'm sorry.
No, I understand your point of view. I get that. I guess I also need to know if it's okay, because Cheryl Sione is my sister's lawyer and she's representing my kids and we live in the same house.
That is something y'all need to take up between each other. I can't do anything about that either.
Okay.
Sorry. Wish I could be more help, but